Hello, my name is Nalini Sharma, and today we are here to discuss the role that international humanitarian law plays when it comes to conflicts like we are seeing in the Middle East between Israel and Hamas. The earliest known source of the popular sentiment, all is fair in love and war, is English writer and playwright John Lyly's first novel, Euphues, published in 1578. In this novel, the author tells the story of a wealthy and attractive young man. And while describing this man's romantic adventures, Lyly writes, "Rules of fair play do not apply in love and war." While a 16th century dramatist saying all is fair in love and war can be forgiven as romanticism, the stories of innocent men, women, and children caught in the horrific Israel-Hamas war portray a completely different sentiment altogether. That there should be some rules when it comes to war in the 21st century. The Israel-Hamas conflict is a complex issue with deep-rooted historical and political dimensions, one that the entire international community has been closely scrutinizing since it began. With the world watching, many countries and international bodies have time and again reminded both Israel and Hamas about their obligations under the international humanitarian law. The UN Secretary General, days after the ongoing clashes began, stated that international humanitarian law must be respected and upheld. The UN human rights spokesperson, in a press conference, said,
"We need immediate humanitarian access throughout Gaza so that we can get fuel, food and water to everyone in need. Even wars have rules. International humanitarian law and human rights law must be respected and upheld. Civilians must be protected and also never used as shields. And all hostages in Gaza must be released immediately."
The international humanitarian law on the aspect of protection of civilians is very clear.
The imposition of sieges that endanger the lives of civilians by depriving them of goods essential for their survival is prohibited under international humanitarian law.
Even closer home, India's spokesperson for the Ministry of External Affairs, Arindam Bagchi, said, "There is a universal obligation to observe international humanitarian law."
But there is a universal obligation, I think, to observe international humanitarian law. There is also a global responsibility to fight the menace of terrorism in all its forms and manifestations. And I think that accurately sums up how we look at this.
But what does the international humanitarian law say about the rules of war, and do countries really abide by them when they are at war? Let's start with what is international humanitarian law. International humanitarian law lays down a set of rules that are designed to mitigate human suffering during armed conflicts. It is critical for regulating the conduct of the parties involved in conflicts like the Israel-Hamas war. Though the law lays down several principles of what countries can, cannot, and must never do during armed conflict, enforcing the law itself comes with its own set of challenges. One key aspect of applying IHL to the ongoing conflict is the classification of the conflict itself. The Israel-Hamas conflict is generally considered a non-international armed conflict, a designation that's used when the conflict involves a state like Israel and a non-state actor like Hamas on a Palestinian territory under its control. As a non-international armed conflict, the principles of international law governing this conflict fall under Common Article 3 of the Geneva Conventions 1949 and other principles of customary international law. At the outset, though, it must be understood that enforcing international humanitarian law during a non-international armed conflict is even more of a challenge than usual for a variety of reasons. When parties to the conflict involve non-state actors, it becomes difficult for the government to control and implement IHL in its own country. presence of multiple armed groups with varying levels of organization makes it harder to identify and engage the parties that are responsible for the violation of law, and many state or non-state actors may simply not have ratified or accepted IHL treaties, which can hinder efforts to make them accountable for what can be possible violations. Efforts to address these challenges often involve a combination of diplomatic, legal, and humanitarian actions with an emphasis on building awareness, fostering compliance, and encouraging parties to the conflict to respect the international law. Additionally, regional organizations, international bodies, and civil society play vital roles in helping enforcement of the IHL, especially in non-international armed conflicts. The primary principle governing international humanitarian law is that parties to a conflict must at all times distinguish very clearly between combatants and civilians. Civilians must never be the target of attack, and parties engaging in conflict, irrespective of whether they are state actors or non-state actors, must at all times ensure that civilians and civilian properties are not harmed. At the same time, laws of the war recognize that some civilian casualties will be inevitable during armed conflict. The burden, therefore, is on the warring parties to ensure that they take all possible precautions so that only combatants and military targets are subjected to attack and not the civilian population. Residences, housing units, religious institutions, healthcare establishment, educational institutions, and historical landmarks are those that fall among civilian structures. Civilian structures may become legitimate targets when they transition into military objects. In other words, when these structures substantially contribute to military operations and attacking them offers a clear military advantage, they may be subjected to an attack. A good example of this may be a situation where an armed group members or military forces are present in structures that are traditionally civilian. But if there is any uncertainty about the status or the object of a property, which means whether there is no clarity whether a property is a civilian property or a military target, then in those cases, it should always be treated as a civilian property by default. Civilians and combatants are differentiated in international law on the basis of whether or not a person is a member of the armed forces. The notion member of the armed forces was first introduced in the Third Geneva Convention of 1949 and later expanded in 1977 through the Additional Protocol 1. Members of the armed forces under international law include persons serving in the national armed forces, along with organized forces of a non-state party and part-time fighters who may be civilians but are directly participating in the hostilities. All of the above can be subjected to attacks during a war. On the other hand, persons not directly participating in the armed conflict, including reservists of the National Armed Forces when they are off duty, fall strictly under the definition of civilians and must be protected at all times. Keeping this in mind, military attacks should be directed solely at legitimate military objectives, and any harm to civilians should be proportionate to the military advantage sought during this attack. The doctrine of proportionality under international law, particularly in cases of non-international armed conflict, is a fundamental principle that governs the use of force by parties involved in such conflicts. The doctrine of proportionality stipulates that parties to the conflict must ensure that use of force is proportionate to the military advantage anticipated from an attack. This means that when parties decide to carry out an attack, they should weigh the anticipated military advantage against the expected harm to the civilians or civilian objects. Under the doctrine of proportionality, not only must force be used that should be proportionate to the anticipated military advantage, but also excessive force or force that is disproportionate to the military goal is categorically prohibited. This means that there must be an ongoing assessment of the situation, and in cases where civilian harm is foreseen, the attack should either be cancelled or postponed unless the expected military advantage outweighs the harm to the civilians. The doctrine of proportionality is designed to strike a balance between military necessity of a particular operation and the humanitarian imperative to protect civilians and minimize their suffering during armed conflict. Violations of this principle can amount to war crimes and may lead to legal consequences for those that are found responsible. However, it is important to reiterate that application of international humanitarian law, including the doctrine of proportionality, in non-international armed conflicts can be extremely complex, as there is often either a lack of clarity regarding the status of certain actors and the application of the law itself. Additionally, enforcement of these principles is heavily dependent on the willingness of the parties to adhere to these principles in the very first place. Rules of war also prohibit the use of indiscriminate attacks. Indiscriminate attacks involve reckless targeting of both military and civilian properties alike. Undoubtedly, the use of indiscriminate attacks in populated areas is a significant concern when it comes to the Israel-Hamas conflict, since Gaza is one of the most densely populated areas in the world. The concept of indiscriminate attacks can encompass various scenarios, including artillery bombardment, aerial bombings, or the use of weapons that simply lack precision in targeting. Warring parties are also obligated to give effective advance warnings of attacks when circumstances permit. What constitutes as an effective warning depends on the specific situation and necessitates an evaluation of factors such as the timing of the warning and the ability of the civilians to evacuate the area. A warning cannot be deemed to be effective if it doesn't afford the civilians sufficient time to move to a safer location. But even if civilians for any reason do not evacuate, even after an effective warning has been issued, they are still to be protected under international law. This is to prohibit a party engaging in war from using these warnings just as a means of displacing the civilian population. With the current conflict ongoing for a week now, Gaza has almost run out of basic necessities like fuel and water, with essentials like food, medicines in dangerously low supply. International organizations, including World Health Organization, have called for health and humanitarian assistance to be provided to the civilians caught in this crossfire. Ensuring access to humanitarian aid in conflict zones is a very important aspect of international law. Parties to a conflict are obligated to allow and facilitate the delivery of humanitarian assistance to civilians in need, even while a conflict is ongoing. In protracted conflicts like the Israel-Hamas situation, the civilian population may face severe shortages of essential goods and services, making humanitarian access of paramount importance. Despite the horrific pictures and videos coming in from the ground of women and children being taken hostage, kidnapped, and even killed, it's important to know that hostage-taking is strictly prohibited in armed conflicts under the Geneva Conventions and customary international law. Hostages include not only civilians, but also members of armed forces who have surrendered or have been detained. The Rome Statute of the International Criminal Court categorically recognizes taking hostages as a war crime. It's essential to emphasize that IHL applies to all parties involved in the conflict, not just one side. Though they might not be abiding by them, both Israel and Hamas are bound by these rules, and violations can result in legal consequences. As parties to the armed conflict, the armed wings of Hamas, Islamic Jihad, and other Palestinian armed groups are also obligated to abide by the law. Additionally, both Israel and Palestine are signatories to significant international human rights treaties, including the ICCPR, as well as the Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment. Any intentional violation of international humanitarian law can be and should be categorized as a war crime. States are under an obligation to investigate and fairly prosecute those within their territory that have been implicated in war crimes. In addition to this, the International Criminal Court can also look into war crimes. And though Israel has signed but not ratified the ICC treaty, the treaty is in effect in Palestine, which gives the International Criminal Court jurisdiction over the territory occupied by Israel since 1967, namely Gaza, the West Bank, including East Jerusalem. The question now is, how much pressure will the international community be able to put on Israel and Hamas to follow their obligations under international humanitarian law, and whether the International Criminal Court will be compelled to step in to take matters into their own hands?